Welcome, everyone. The Fort Worth, Texas police officer who pulled the trigger and killed an innocent woman because her front door was open has been indicted on a charge of murder. A grand jury decided that former officer Aaron Dean should be tried in the case, agreeing with a prosecutor's decision to charge Dean with murder 2 months ago. Jefferson's neighbor called 911 because her door was open late at night. Body camera video showed police looking around Jefferson's home with tactical flashlights. When Officer Aaron Dean approached a window, he saw Jefferson and ultimately fired. Police documents say officers later interviewed Jefferson's nephew, who said Atatiana saw lights in her yard and went for a gun. Police later released a freeze frame of what is believed to be Jefferson's gun laying on the floor. Attorney Lee Merritt, representing the victim's family, tweeted reactions several times today, saying in part, Atatiana's family is relieved but remain cautious that a conviction and appropriate sentence is still a long way away. Though her family is relieved by the news, we need to see this through to a vigorous prosecution and appropriate sentencing. The Fort Worth Police Department released video of suspect Aaron Dean's job interview in 2017 after local reporters filed a public records request to see it. Dean explained back then why he wanted to be an officer, and his words now sound chilling.
When I was a kid, I wanted to do the military, thought about it, just never did it. Should have in retrospect, and so this is kind of a way to do some of those same things without having to deploy overseas. Also just finding unfulfillment in the desk job and the day-to-day grind and wanting something that's more active, something where I actually get to go out and to interact with people and help them in a very immediate way, whatever the situation might be. Time to fight is certainly if I'm under or someone that I care about or I'm responsible for is under imminent threat. I do have a license to carry and carry every day, and that, of course, is constantly on my mind as I walk around carrying a weapon for self-defense or defense of others.
Will you be able to kill somebody if you have to?
No problem.
3 attorneys are with us tonight. Let's begin with Eklund Mercy in Atlanta. So, Eklund, procedurally, the authorities already charged Dean, but the law in Texas requires an indictment. So is this merely a rubber stamp on the charge, or is it an indication that, well, a grand jury agreed this was murder and maybe a trial jury would think so too?
Yeah, I think that they're trying to protect themselves. Remember, this is the same Dallas that just had the Amber Geiger case. So they should be, they're trying to cross every T, dot every I, and make sure that they follow procedural rules with regards to that. But just like Amber Geiger case, HR should all be fired. That man sounds like he has a thing to prove. He already said that he would love, he wasn't good enough for the military, just like Amber Geiger, but he's good enough for Dallas and is put to shoot on site.
Michael Bryant, can this officer, former officer Dean, claim he fired in self-defense here? Because remember, you've got him basically saying, well, there was a gun involved, it was on the ground. Does he have enough of a claim to kind of go that way?
I think there's enough to make the claim. Remember when this first unfolded, as Eklund said, right on the heels of the Amber Geiger case, the heightened awareness of this event made him guilty in the public opinion from the start. And then we started to hear that maybe there was a gun in play. And then we saw the video of one on the ground. And then we heard that the kid that she was with playing video games testified or told the cops that she, in fact, went and got a gun. The question is going to be how much time passed between him saying, let me see your hands, and firing. That's what it's all about.
And it was just a couple of seconds. It was very, very quick. And it was startling, certainly, for the victim who was actually shot and killed here. Catherine Smith, let's talk about that job interview recording. It's disturbing to look back at it here. The question is, can prosecutors try to introduce that into this case to try to prove intent, or is it just too far removed, listening to him say, well, I really wish that I was a commando or something like that, but I became a police officer instead so I didn't have to deploy?
They can try, and I'm sure that they will try, but it's really hard because it always has to withstand that test of, is it more probative than it is prejudicial? And I honestly think that it really behooves the defense to focus, or to the prosecution to focus on exactly what happened that night and that he really acted inappropriately.
Eklund, very quickly here, did he sound trigger happy in that job interview to you?
Absolutely. Absolutely. He was ready. He wants a job in which he can shoot guns, but he wasn't strong enough for the military. So he settled for Dallas Police Department. Apparently that is the type of police officers that they hire.
Fort Worth. Well, let's move on to another city in Texas here. Police in Austin have found a baby girl missing for more than a week, but they also have found what they believe is the dead body of the girl's mother. Heidi Broussard and her newborn, Margot Casey, vanished around 7:30 in the morning back on December 12th after she dropped her older child off at school. A suspect in the case is charged with kidnapping and tampering with evidence, a human corpse. But police are not confirming that suspect's name just yet.
A lead was generated that created a location of interest in the Houston area in Harris County. Federal, state, and local resources deployed to that area of Harris County and began to investigate a residence there. Ultimately, those investigators encountered an individual outside of that residence who was detained. During that search, we located a baby who is currently safe, currently healthy, who is currently in the care of Child Protective Services. The Harris County Medical Examiner's Office is conducting an autopsy today of the deceased adult female to determine the cause of death, determine the manner of death.
Federal authorities say they do have surveillance video from Jeffrey Epstein's jail cell after all. Yesterday, we reported that prosecutors told a judge that footage from the millionaire pedophile's first suicide attempt was missing. They now say they have it. Cameras captured the footage several weeks before Epstein finally did die. Yet another civil lawsuit against movie producer Harvey Weinstein and others, including Miramax and Disney, as Weinstein's criminal trial is just weeks away. Polish-born model Kaja Sokola says Weinstein sexually abused her shortly after she arrived in New York at age 16. She was a plaintiff in a master settlement, using a different name, however, but she decided not to agree to the terms and is now suing under her real name. Her claims are being filed under New York's Child Victims' Rights Act, which reopened the statute of limitations for some sex abuse cases. The plaintiff was part of that larger lawsuit, as we said, but dropped out of it. She says, "I cannot accept the proposed global settlement as fair or just. There is no accountability for the perpetrators, insufficient compensation for all of the victims, and millions of dollars going to people that I believe enabled Weinstein." We spoke with several of Weinstein's accusers for a special one-hour look at the cases against that movie producer. Accuser Caitlin Dulaney reacted this way to that recent $25 million global settlement.
I'm very much in support of the settlement. I'm actually a lead plaintiff in the class action that negotiated the settlement. So I've known the ins and outs for 2 years. I know what the limitations are. And I've always felt, as a lead plaintiff in the class action, that I was doing this for all of Harvey Weinstein's victims. And it is very unfortunate that big business and, men with a lot of power can continue to kind of squeeze something like this into such a small amount. And it was a really difficult thing to go through. The Weinstein bankruptcy, really limited what the settlement could do, but it is still something that even women who haven't come forward yet, if it's approved by the court, will be able to file a claim. All of the women that were assaulted by Harvey, 80 plus, 90 plus, I'm sure many more, deserve some kind of relief and recompense. There's the criminal and there's the civil, and it's really important to try to bring justice for all of these women in both arenas.
Back again now to our guest attorneys tonight. Catherine Smith, I'll start with you. This is a really interesting use of the Child Victims Act right here in New York to go after this guy. We've got an accuser, 16, and this new lawsuit coming out just weeks before the criminal trial.
Right, it's interestingly timed, and also it's completely appropriate under the act for her to sue. It's interesting because a lot of people who could claim as a part of a class action, they tend to opt in, they tend to go for it. It's not typical that we see someone who would opt out in such a public way.
Eklund Mercy, so Weinstein's being hit with case after case. Given this accuser's age, is it possible that she'll get a bigger award outside the global settlement if she proves her individual case here?
I think so. I think that this case has been, it's been in the media. People, it started a whole movement. So I do believe that her age definitely will reflect the larger settlement. You can make the argument that she wasn't, mature enough to deal with being, she was groomed and she was molested by this this grown man.
Michael Bryant, we've got a criminal trial coming up here. It's really interesting to see some of these settlement talks coming up before an actual criminal trial. The procedure is a little bit backwards for what we usually see.
Yeah, quite often the criminal trial will resolve, and then whatever the result is applied somehow to the criminal case. You know, you don't take one of these decisions lightly to opt in or opt out. It's really dependent on the strength of your case and really the strength of your emotional well-being, because it's not fun. It's not fun at all. So unless you're ready for what's to come, opting out is a gutsy call.
And this accuser is saying that she moved on, that she now works in psychotherapy and gave up all those plans to act and be a model, in part because of what she says Weinstein did to her. And still ahead tonight here on The Debrief, the penalty phase of the trial involving the shooting of a state trooper. The testimony from Trooper James Casey explaining how being shot in the face affected his family, his colleagues, and himself. Welcome back, everyone. An Arizona jury has given a judge a list of aggravating factors to consider when the judge finally sentences convicted cop shooter Ramon Bueno. The same jury delivered a partial guilty verdict against Bueno for shooting Trooper James Casey in the face and also shooting toward other officers. The jury was deadlocked on a more serious attempted murder charge. During this penalty phase of the case, Trooper Casey told the jury how the shooting affected him mentally, physically, and financially.
I've had to retire from the police department because of this. I've suffered PTSD. I have, when I first got out of the hospital, I would go weeks with sleeping for an hour or two. I just could not sleep. I have medical issues as far as I cannot have an MRI because of the bullet fragments in my head. My nose, I have trouble breathing at times. I mean, you can look at me, I got scars on my face. I have prosthetic teeth, so I can eat. I can never chew gum. I used to love chewing gum. I can never chew gum again.
Trooper Casey then explained how his 11 and 15-year-old sons found out their dad had been shot in the head.
My oldest son, when DPS called and told him that I had been shot in the head, he went on the computer to try and find any information, and the only thing he could find was the audio call that you guys heard. So he has no idea, and he heard my dad basically has been shot in the head, and they had no information. My youngest son, Brandon, when he came to the hospital and saw me, he jumped on the. I asked him. He was just stuck there looking at me, and I told him to come over, and he laid in the bed and he buried his head, and all I could feel was underneath. I was just getting wet with him crying, and he was just pleading with me. He's like, "Dad, you're not dying, are you? Please tell me you're not dying." And I was like, "No, Brandon, I'm out of the woods. I'm not dying. You're okay."
Trooper Casey said the ordeal took an obvious toll on everyone in his life, his family, his friends, and himself.
I remember my father, he's in his 70s, I was probably a day out of the hospital, and I remember he collapsed in my arms crying, and I'm trying to hold him up, and I'm as weak as I can be. It took a toll on all of my family. It was, my wife told me, which there are times that I don't remember, but I do remember, she's told me that I could be very nasty to her when I was under sedation. I didn't know that. I don't remember that. I always wondered, when I looked at Ray, when I went back to work a year and a half later, he'd always look at me if I was in a traffic stop or somewhere in that area. He'd always kind of look at me like, why? And I never really grasped why he was doing that until I heard him the other day. I didn't know he was pulling basically pieces of my mouth out of myself so I could breathe. So now I have a better grasp on why he was always like that. Anybody who's known me growing up, I always wanted to be police from the time I was little. And this is not the way I wanted to end my career. I didn't want to end it at his hands, especially.
This is the penalty phase of the case, and prosecutors explained the aggravating circumstances to the jury, then asked the jurors to think of the victims in this case.
Those men had careers ahead of them, young, successful, seasoned law enforcement officers, and that all came to an end because of the defendant. You know the defendant was a gang member. Both co-felt jets in the Arizona Mexican Mafia. You know that, in fact, the ultimate act of prestige is shooting a law enforcement officer in the face. Now, you also know there were dual motives here, and you're allowed to look at dual motives. He was not going to be taken into custody. That was the motive for this case. But you also know, based upon Detective Clint Davis's testimony, that that is one of the mandates of the Arizona Mexican Mafia, to stay out of custody and to continue doing their deeds. You know that he did this in front of Danny Vargas, and how that will help his status when Danny Vargas can serve to say, oh yeah, he was there, I did it. This was the ultimate crime for Ramon Bueno. Just didn't get away with it because of you. But did it help the Mexican Mafia? Absolutely. And he knew that because you know he was extensively documented as a member of the Mafia.
The defense says, wait a minute, not so fast. The state didn't prove Bueno is in a gang. The defense contested the findings of the state's gang expert, retired Detective Clint Davis.
Ms. Dahl told you that the gang allegation or his gang affiliation wasn't challenged. We didn't cross-examine Clint Davis, but we argued it. It doesn't mean it wasn't challenged. Clint Davis sat in here with no documents. He talked about tattoos, doesn't know when they were received. Talked about what he thought they meant. You blood in, blood out, you can't get out. There's nothing to support his assertions. And then within the evidence in the case, where's the evidence that somehow this advanced the American-Mexican Mafia? It's rank speculation. Now, Mr. Davis, a retired detective, spent a lot of time studying groups. He had no documents. He hadn't had a run-in with Mr. Bueno. His testimony was based on tattoos and company. What if people grow up in the same neighborhood? That's who you're going to be found with. Doesn't mean they're advancing a gang initiative by being together in a car or being together in a house on West Vista later. That aggravator falls short. It falls way short. The others may too. You decide.
The state's rebuttal argument was basically that some of the aggravating factors were just really simple.
Arguably, it's inherent in your verdict, but it is a necessary part of our judicial process to go through and have the findings made by you, members of our community. In this circumstance, the use of a firearm, there were specifically different types of language that the law provides for. Now, if there's a concession that your verdict is inherent to it, then your job is very easy. Was a firearm used? Yes, so it's a dangerous offense. There was the serious or threatened infliction of serious physical injury. You shoot a gun toward law enforcement officers, they might just hit. The gang aggravating circumstance, you know based upon the testimony from Detective Clint Davis, this isn't speculation. This is based upon documentation. And you heard about the fact that he had reviewed extensive documentation. These aggravating circumstances are present. There needs to be a review of the evidence in this case for each one of the 5 that has been presented to you. And we would ask that you, again, apply your common sense and a review of the evidence and make the findings. They have all been proven beyond a reasonable doubt.
Those were the arguments. Here is the jury's verdict as to the penalty.
Aggravating circumstances. The offense involved the infliction or threatened infliction of all serious physical injury. Unanimously proven. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. Unanimously proven. The offense caused physical, emotional, or financial harm to the victim. Unanimously proven. The offense was committed with the intent to promote, further, or assist any criminal conduct by a criminal street gang. Unanimously proven. Signed, foreperson. As to counts 2, 3, and 4, and 5, aggravating circumstance. The offense is a dangerous offense. Unanimously proven. Signed, foreperson. Are these your true verdicts? So say you one and all?
Yes.
Let's round out the show with our panel tonight. Eklund Mercy, let me start with you here. The jury was hung on this attempted murder charge, so the defense can sit there and say we kind of won. But what do you make of this tactic at this phase of the game to call no witnesses for the defense and basically argue with the state's gang expert, even though there were all those pictures of tattoos and everything on the screen?
Yeah, I would do the same thing, because besides being Hispanic and having tattoos, that does not equal, hey, he was a member of the gang. You need to have more information. The state needs to come better, and they did not. And I think that this is an absolute opportunity to really put the expert and just say, hey, do we have any more evidence? Do we have any more information than just tattoos and his nationality?
Catherine Smith, if you're a prosecutor, do you try this defendant again on that attempted murder charge, or do you just wait and see how long the judge stacks everything up on the convictions that the prosecution did secure and then decide?
I think I would wait. I think it's more prudent here to wait and see and stack up instead of just going right out the gate and try to retry on that charge. You know, you really could get an inconsistent verdict, and I think it's better to really wait it out and see what happens here.
Michael Bryant, these aggravating factors, though, to me seemed like relative no-brainers, because once the jury decides that Ramon Bueno had the gun and shot this trooper and tore the other troopers, he used a gun. I mean, they made that decision, and then they found, oh yeah, he used a gun as an aggravating factor. I mean, maybe the gang affiliation you could contest a little bit, and that's what the defense did. But the rest of them pretty much fit what the jury decided back in the original phase of the case.
Yeah, you're right. I mean, no surprise at all. And, you know, ultimately the sentence handed down could exceed what it might have under the top charge. And I think that's why the prosecution will wait for that. But it's also interesting, I think, to see this gang affiliation issue arise on appeal. It will. We know they moved for a mistrial when that gang expert testified. The defense stood up, wanted a mistrial. Denied, of course, but that was paving the way for the appellate issue, I'm sure.
Catherine Smith, many of our guests have sat around the table here and said, you know, isn't it interesting how this gang affiliation testimony goes right into the attempted murder trial in Arizona, where in many states that would have to be tried separately?
Right, I agree. I think it can be extremely prejudicial, and there needs to be a little bit more there, to Eklund's point, of someone's ethnicity and tattoos. I really think that that was very weak, and it's going to be interesting to see what the appellate court decides.
Michael Bryant, would you try him on the attempted murder charge or not?
No, I think I'd wait, and I really think if the sentence is in excess of or equal to what it might have been, you leave that one alone.
All right, we're going to wrap up here on the debrief. Thanks a lot for those of us sitting around the table, our panelists here tonight. Thanks to those of you for watching. Have a good weekend. We'll see you back here at Law&Crime on Monday.